Greetings from Englewood Municipal Court. You're watching this advisement of your rights because you've been charged with a violation of an Englewood Municipal Ordinance. The main purpose of your appearance today is to be advised of the rights you have in your cases. It's important that you understand these rights because when I finish with this advisement, you'll make a decision that will affect your rights. The decision you'll make is whether you want to enter a guilty plea today, thereby giving up your right to have a trial in your case, or if you want to enter a not guilty plea, thereby preserving your right to trial. You have the right to have a trial in your case, and you can either have a trial to a judge or a trial to a jury of your peers. If you want to keep your right to have a jury trial, you must pay a jury deposit of $25 today or within 21 days of today's date and submit a written jury demand. If you cannot afford the jury deposit, you can file a written request and financial affidavit within the next 21 days to have the jury deposit waived. However, if you do not pay a deposit or have a waiver granted during the next 21 days, then you would not have the right to have a jury trial in your case. You also have the right to be represented by your own lawyer throughout your case, including at your trial. You can hire a private attorney of your own choice at your own cost to represent you. However, you also have the right to request that an attorney be appointed for you, and if your case is one in which jail is a possibility and you meet the financial qualifications, the court would appoint court-appointed counsel at no cost to you. If you are in custody, a court-appointed lawyer will be provided at no cost to you today and for as long as you remain in custody. You're not required to have a lawyer since you also have the right to represent yourself throughout your case. Everyone is always presumed to be innocent of all charges against them. That means you will not be found guilty of any charge unless you either decide to enter a plea of guilty or at a trial the city can prove you are guilty beyond a reasonable doubt. If you have a trial, the city will be required to bring a witness or witnesses to the trial to testify, and you would then have the right to cross-examine any of the city's witnesses. When the city has completed presenting their evidence at your trial, you would then have the right to present your own evidence in your defense. However, you do not have to present any evidence since it is not your burden to prove that you are innocent. Rather, it is the city that must prove that you are guilty beyond a reasonable doubt. If you decided that you did want to present a defense at trial, one way would be by having a witness come to court to testify on your behalf. If a witness would not come to court voluntarily, we could issue court orders called subpoenas, which require the attendance of your witness at your trial. There is no cost to have a subpoena issued, but it is your responsibility alone to ensure proper legal service by having someone over the age of 18 who is not connected with the case in any way give the witness a copy of the subpoena with adequate notice of the date and the time of your trial. You also have the right to testify in your own defense at your trial, but you're not required to testify. In fact, you have a constitutional right to remain silent throughout your case. That means you do not have to make any statement at any time during your case. If you exercise your right to remain silent, it cannot be used against you. However, anything you do say could possibly be used against you at trial. If you decide not to testify at your trial, no one can say you must be guilty simply because you chose not to testify. The jury could be instructed that they were to draw no conclusions about your guilt simply because you did not testify. You have the right to testify at your own trial if you want, and if you do testify, just be aware that you will be cross-examined by the city attorney's office. If you've ever been convicted of a felony, that information can be used to impeach or discredit your testimony, but not offered as direct proof of your guilt in this case. At the end of the trial, if you felt there was some error, you could appeal the case to a higher court and a different judge. If you enter a plea of guilty or you're convicted at trial, the maximum possible punishment for each offense is up to 360 days in jail and a fine of up to $2,650. If you're not a U.S. citizen, a conviction for certain offenses may have consequences regarding your presence in the United States. You should seek legal advice if you have immigration questions prior to any trial or entering a guilty plea. Also, if you have prior U.S. military service or are a current member of the U.S. military armed forces, you should be aware that you are entitled to receive mental health treatment, substance use disorder treatment, and other services as a U.S. veteran. Upon request, the court office will provide you with a list of service organizations that will assist you in your efforts to obtain these services. Before I decide what punishment to impose in a case where there's been a plea of guilty or a conviction at trial, I can review all relevant information about your case. That includes your criminal history or driving record if applicable, as well as statements of witnesses, victims, and police officers. However, before I make my final decision, you are always given the last opportunity to tell me anything about the case or anything about yourself that you think I should know. In a moment, we'll begin calling today's docket of cases, so please wait for your name to be called for further instructions. We will see you soon, so thank you for your patience.